Okay, welcome everybody to the Saturday night free online law class for Vocational Science of Freedom. And tonight will be Class 4, Docs and Links, which is the discussions of settlement over states and claiming our birthright. Last time we left off with a document that we were covering, which started off as a long email to new students. And if you want to find the document and follow along, you can click on the mega link in the Class 4 Docs and Links folder, or if you're listening online, you can find the link to these docs in the description on whatever platform it gets uploaded to. So, as I said, we left off with what is a person? So, what is person? A lot of people tend to get this wrong, particularly those that have been given false information over the years. A lot of people used to think that they'd say, oh, your person is a corporation. Well, no, your person's not a corporation. A person can be a fiction of law. Is a corporation a person? Yes, a corporation can be considered a person, but that doesn't mean that what they're calling a person in statutes, acts, ordinances, and codes, how they apply it to you under Roman civil law, means that your little thing is a corporation. That's an estate, and it's also considered an infant, and I'll show you here. So this definition is from the United States Code, which controls all things on the federal level. And remember, after the Civil War, everything is being controlled on the federal level by the Livery Code, right? That's Executive Order 100, because the states are conquered territories under the control of the federal government. And if you doubt this, you can write a letter to the Congressional Research Office and ask them that question point blank, and you can get the answer. So, under the Act to create a government for the District of Columbia in 1871, they created a separate corporation and city-state, not unlike the Vatican and the City of London, which was created in 43 AD by the filthy Romans. City-states have separate jurisdiction from the rest of the nation or area which may surround them. And the District of Columbia got established and created and made it look like it was just continuing on what the original trust of the United States of America had been doing after the Civil War, but that was not the intent. The intent was to create a separate corporation and bring everybody under it, very much like the Crown in England. They liked that system, and they wanted to do exactly that. So they did. And because the original trust was bankrupted in the Civil War, which was the United States of America, also labeled as the Confederacy, if you look at the Articles of Confederation, the same style is there in both, that once that trust / confederacy was bankrupted, then they moved in and created a corporation to take over the 19 enumerated services that were laid down in that particular trust's constitution, which of course was a agreement between the states. That, of course, I'm talking about the federal constitution here. And the individual states are republics, and the federal government has always been a trust between those states. And after it got bankrupted, what they tried to do as quickly as possible was they wanted to set up a corporation to then run everything through it and run everybody through Roman civil law by force, fraud, lies, presumption, pledging, and coercion, basically, and contract. And one of the major contracts, of course, was the 14th Amendment, wherein it says that one who is born or naturalized and subject to the jurisdiction thereof is a citizen of the United States. Now, we the people are not subject to the jurisdiction of Congress or anyone. And I just dropped a link in the server today. Dropped it under state law and case law. I dropped it under Washington, which I forget. Yeah, when you do these things, it pops up as the top. Okay, so what I want to show here, now those in California, now this is Washington State. This is not DC. But I just want to show something that people in California might recognize if they've read their government code. So this is the Washington Freedom of Information Act. So I'm just going to read it. The Washington Public Records Act, under Chapter 42.56 RCW, is a series of laws designed to guarantee that the public has access to public records of government bodies at all levels in Washington. The introduction to the statute explains the reason for the PRA. Quote, the people of the state, lowercase s state, notice that, the people, lowercase sp and lowercase s state, the people of the state do not yield their sovereignty to the agencies that serve them. The people, in delegating authority, should really say vested authority, but whatever. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may maintain control over the instruments that they have created. Close quote. Who's in charge? The people are. The people of the state do not yield their sovereignty. Who's sovereign? Only the people. This is current law. Now, maybe your state's Public Records Act might say the same thing. I was kind of astonished to find this in a Public Information Act, but it is stated in the California Government Code. I know that. I would like to find a line like this for every single state, because the hierarchy of how this republic is set up is we the people are on top with our grand juries and our petite juries. The states are below us, and the federal government is below the states. That's how all this is supposed to work. And you can clearly see that by this language. So, just wanted to make a note of that. So, what they did was, in bankrupting the original trust, is that they wanted to bring everybody under one of their filthy corporations, under Roman civil law, by consent. What did Jefferson say? Jefferson said that the just powers of government are derived by the consent of the governed. Well, guess what? It means any government, even if it is a filthy corporation. If you're still allowing some filthy corporation to govern you, well, then you've done so by consent. You've asked for it. You stepped up and said, yeah, please, Daddy, please, I need permission to do this, right? Like as in getting a driver's license, which that's a dual-edged sword. I probably shouldn't have said it like that, because a driver's license technically is prima facie evidence that you are using the roadways as a place of business, as either a for-hire carrier or a contract carrier, meaning like for-hire, like, hey, take me from one place to the other, like a taxi cab, or, hey, drive my stuff, whatever it may be, bales of hay to iron ingots, doesn't matter, from Texas to California. Okay, if I'm paying you to do that, then you are driving something for me. If I am not engaged in commerce, then I have the right to freely access the roads and travel wherever I bloody well want to. And that difference of being in commerce or not is the major difference in being in a contractual relationship with a corporation or corporations that are acting as government. So when they established the District of Columbia in 1871, they created a separate little city-state, separate little corporation, and they called it the United States. Clever, clever, right? And what the United States Code says right here, so this is Title 1, United States Code, subsection 8. Definition: person, human being, child, and individual, as including born alive infant. Now, when you say the words include or including, in statutory construction, what something includes is this and nothing else. So if I were to write a statute that said trees include elms and oaks, a pine tree would then therefore not be a tree under the definition of tree in that statute. So just keep that in mind here while we're reading this. So in determining the meaning of any act of Congress or of any ruling, regulation, interpretation of the various administrative bureaus, which is all there is. It's just administrative bureaus because you're just dealing with a corporation. And agencies of the United States, that's the United States Federal Corporation, which you can find that under 28 U.S.C. Here, I'll just type it in here really quick. You can find that under 28 U.S.C. 30 15A. If you don't believe that the United States is a corporation, just go look that one up, and it'll tell you the United States is a federal corporation. It's right in their own code, okay? So, to get back to this, in the meaning of any of these acts, rulings, or interpretations, various administrative bureaus, agencies in the United States, the words person, human being, child, and individual shall include every infant member of the species Homo sapien who is born alive at any stage of development. Are you an infant? Well, depends. The opposite of an infant, as far as common law terms are concerned, means having come of full age. That's the term under common law to rebut the presumption that you're an infant. So, and where is that? That term, come of full age, goes all the way back to the Magna Carta, which was signed in June 15th, AD of 1215. It's a long time ago. So I'll scroll down here and show you. Basically, the main sections of the Magna Carta that pertain to what we're still dealing with are Article 3, 4, and 5. But right here, you'll see. But if the heir of any of the above persons, now don't think of this word as how it was just defined previously. This is different, because this is going all the way back, meaning an actual living man or woman. So, but if the heir of any of the above persons shall be under age and in wardship. Now, above persons, what were they talking about? They were talking about the barons and earls, meaning members of the peerage. Now, we in America are members of the sovereignty. We in America don't use these titles anymore, but we're all sovereign, as clearly the law that I just showed everyone from Washington clearly said. So, this is who their above persons are talking about. Members of the sovereignty, right? Members of the peerage. Okay, shall be under age and in wardship. When he comes, what? Of age, he shall have his inheritance without relief and without fine. Okay, comes of age means you can take care of your own affairs. In some translation of the Magna Carta, it says comes of full age. There'll be a full in here. And sometimes it'll say comes to full age. So sometimes this of will be a to, depending on the translation. So if you're an infant, this is how you end being an infant. You've come of full age. So the administrator of the land of such heir, who shall be under age, shall take none but reasonable issues from the land of the heir. That's what you are. You're the heir. You're the heir to your estate. And reasonable customs and services, and this without destruction and waste of men or goods. If we shall have committed the custody of any such land to the sheriff, or to any other man who ought to be responsible to us for the issues of it, and he cause destruction or waste to what is in his charge, we shall find him, and the land shall be handed over to lawful and discreet men of that fee. Now this is exactly what they do when they keep exchanging and moving your estate between attorneys and judges. The next attorney and judge, 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 handed over to two lawful and discreet men of that fee. They just keep passing it off. They just keep passing off the administration, right? They keep passing off the administration of your estate between themselves. And they keep fining and feeing you for the use of it. And if we shall have given or sold to any of the custody of any such land, and he shall have caused destruction or waste, he shall lose that custody, and it shall be given to two lawful and discreet men of that fee. So again, even if the attorney and judges keep abusing you, they just pass it off to the next person. Kind of like, like an appeal. You get railroaded in the trial court. Oh, I'm going to appeal it. So what do? You just pass it off to two more black-robed priests of El. Like, that's going to get you anywhere. Well, it depends on what they're doing. Are they violating their own Roman civil law? And have they bound themselves to uphold and obey that through contract? Okay, then it's a contract issue. That's basically how Roman civil law works. They bind themselves to it by stating that, yes, I'm going to be subject to this, that, the next thing, right? And they think that we do too, but the vast majority of the time it's not the case. It's all but done by presumption. And then number 5, the administrator, moreover, so long as he shall have the custody of the land, shall keep in good order the issues of that land, houses, parks, lakes, wharves, mills, and other things pertaining to it. And he shall restore to the, what? Heir. When what? When he comes to full age. So, when you come to full age, that's when you stop being an infant. But there's a process for that, which I'll get into in a minute here. So, this is what they're doing. All all the United States Federal Corporation is doing in the District of Columbia is just administering the estates of infants. That's it. Because you haven't come forward, claimed the estate, and said, hey, hi, I've been found to be living. This is mine. So down here, as we continue, you are not only considered to be dead by presumption, you are also considered to be an infant. So if you come forward and claim your estate, then the proof of which is in the BC contract itself, which the original of which is sitting at the DTCC, which nobody ever gets to see, but we might actually eventually be able to get the originals back. So the DTCC has the original BC. So by looking up the DC code, which is the next thing, it is shown that trust companies are the guardians of the abandoned wards. So it took me a long time to figure out where the administration was being done at and how they were doing it on the federal level. But in taking a month of my time and going through every single DC code that had the word estate in it, I finally found it. So this problem of having a right to having to hold your entire estate is a very, very old fight between the cult of Rome, meaning Roman civil law, and the common law. And if you look at these passages from the Magna Carta in 1215, which we just did, and see that the barons told King John in no uncertain terms that they shall have their entire estates. When? What? When the ward has come of full age. And then you look at the DC code in regards to who are the guardians of infants spoken of in DC code. So the appointments of the guardians of persons by court. Limitations, number of wards. When an infant has neither a natural nor testamentary guardian, which have been something by will, a guardian of the person may be appointed by the probate court in its own discretion or on the application of a next friend of the infant. Well, the attorneys can act as next friends, basically to set it up like that and to change the guardianship. But B is the interesting part. Only trust companies may act as guardian of the person for more than 5 infants at a time, unless the infants are members of one family. So it shows you right in the DC code that it's trust companies that are acting as the guardians. Okay, now we just read the Magna Carta, so I won't go through this again. But again, this is it makes a point here. It all connects from the Magna Carta, from what they were fighting, from the filthy fools that came over in 1066, William the Conqueror and the rest of the idiots, and what the barons had to fight against then about how Rome tries to enslave the entire planet. And then what we have to deal with from the standpoint of where it shows that this is what they're doing by trust companies, and that what a person was, an infant, and then the difference between executor and administrator. Now this again is what I covered last time regarding the difference between executor and administrator. You always want to be the executor, because the executor is the one that has control of the estate. So the word executor, taken in its largest sense, has several applications. One, executor datavis, who is one called an administrator to an intestate. Intestate means without a will. Executor testamentarius, or one appointed to the office of the last will of the testator, and this is what is usually meant by the term. What the attorney does is called interplead. The capacity and ability to interplead was something that was laid down in the Westminster statutes. Now, I don't have that up right here to be able to just pull up, but if you want to, you can look up the Westminster statutes and look for the word interplead. To interplead is to get in between an heir and his or her estate before they've claimed it. That's called interpleading ability. That's exactly what happens in every single filthy Roman civil law court not of record in this entire landmass that is now being taken over by corporations. Okay, that's what the attorney does. They interplead. So this presumption of the aspect that there's no executor, it's because the attorney got in and interpleaded in between you and your estate before they had a capacity to, before you or your father or someone came forward to be able to claim your estate. So, in the civil law, the person who is appointed to perform the duties of an executor as to goods is called aries testamentarius. Aries is another term for heir. The term executor, it is said, is a barbarism unknown to that law. So the Roman civil law doesn't recognize the term executor. So when you walk into a Roman civil law court and say, I'm the executor, they don't know what to do. And again, since I covered this last time, I won't go through this all ad nauseum as I did last time. So, but just make sure to go and listen to the the previous lecture to get to the rest of this. Now, this is one thing I didn't have in the last one. I didn't have administration, so I'm going to go over this real quick. So administration, trusts, the management of the estate of an intestate. Again, what's an intestate? It's one without a will. A minor, which is an infant, right, as we saw the definition. A lunatic, because here's the thing. If they don't see you as dead, an intestate, if you say, hi, I come before the court as having been found to be living, and you break the presumption that you're an infant, you say, I've come of full age, one of the first things they're going to do is they're going to try to do what's called a competency hearing. They'll try to put you under the bus as a lunatic. They'll say, oh, he's crazy. Well, it's because you've already gotten rid of the other two presumptions that they would use to do business as usual, because they have no idea what to do when you remove all the presumptions lawfully and stick it in their face. They get extremely scared. But that's the first thing they'll do is they'll say, oh, you're crazy. Oh, they're nuts, right? So they'll do a competency hearing. You'll hear the district attorney say, Your Honor, state moves for a competency hearing. Or sometimes the judge will even do it. The judge will say, the court comes upon its own motion for a competency hearing. No, that's because I just took your jurisdiction away. Because these people are thieves. A lunatic, a habitual drunkard, or any other person who is incapable of managing his own affairs. Entrusted to an administrator or other trustee by authority of law. Now, this is the thing that gets me about what some other people keep saying online or in various different places. They keep saying, well, you can't control it because you're not the trustee. You don't want to be the trustee. The trustee is the one that has to take the orders from the executor. If you go walking into court and say you're the trustee of the estate, they'll love that. They'll absolutely love it. They'll say, great, trustee. You get to perform the actions of the administrator, which would be the judge, so you can go sit in jail, right? So to continue, in a more confined sense, and in which it will be used in this article, administration is the management of an intestate's estate, or of the estate of a testator who, at the time of administration, was granted, what? Had no executor. That's the point. If you don't have an executor, you're going to have an administrator. If you're the executor, then you can't have an administrator, can you? So that's how we take care of it at the Vocational Science of Freedom. We make sure that in the doc set, you have appointed yourself the executor of the estate. The estate name is what is on the birth certificate. And then they create various trusts from that estate name. An intestate estate is an estate with no will. And this again is why why you do your doc set as a continuation of your will. So there's 9 or 12, depending on your situation, different documents that are part of the Vocational Science of Freedom status doc set. And they're all a continuation of your will, for the exception of the last couple too, because they deal with certain matters that certain people might have to deal with court, which would not be a continuation of your will. They're appointments. But all the rest of them are a continuation of your will. So, and then definition 2 here for administration. Administration is granted by a public officer duly authorized to delegate the trust. What? What trust? It's because your estate has been broken up and put into various different trusts. And they split it all up to hell and creation. You have a Social Security trust. You have, every single time that a court case is created, creates a new trust. Because you'll see the name change. And it's a different bonding. It's a different bond. You have things called minor accounts, which are running around out there, that are all in trust. But the point about the understanding of a trust and estate is that you can't have a trust without first having an estate. The estate comes first. And that's where a vast majority of everybody misses the mark here in trying to figure out what they've done and how to undo it, is that they keep thinking that, oh, they put everything in trust. Well, what comes before a trust? An estate, always. So to continue, he is sometimes called surrogate, judge of probate, register of wills, which is what we do at the county level. You go to the county recorder. The county recorder is the register of wills, right? And for granting letters of administration. So if you go and you record your will at the register of wills, the county recorder, and state that you're the sole lawful executor of the estate, who then controls the estate? You do. But you'd better know what you're doing, and you'd better demand accounting and do things that you're supposed to be doing to settle the estate. That's the point. You have to settle the estate. That's your job as the executor. And then to give everything to the heir, which also happens to be you. You're just wearing a different hat. In general, the right of administration belongs to him who has the right to the venue of the what? Of the personality. Think about that. Think about what that just said. Has the right to the venue, the place of the personality. As if A make his will and B appoint his executor who dies intestate, and C is the legatee of the residues of A's estate, C has the right to administer, right of administration, cum testamario axio, sorry. And this is just they do this interesting little, they're almost like little math problems in law. But what they're getting at is that the administration falls to the last person who needs to do what they're supposed to do. The executor is by will. Administrators appoint an executors by will. So you can only have one executor at a time, as long as the man or woman is still living. But administration, because it's court appointed, can bounce around all over the hell in creation it wants to. And that's usually what they do. They keep moving it around. Then number 3, there are several kinds of administrations besides the usual kind, which gives the administration the management of all the personal estate of the deceased, because you're considered a decedent in your IRS master file, for an unlimited time. Administration, so I'm not going to read the rest of these because they're tricky Latin, but the point is, once they take control of the presumption of intestate in infancy, and that presumption is never rebutted, they administer the estate for an unlimited time. They never ever let it go. That's why the estate's whole existence is always on bond paper. The BC is printed on bond paper. You see a copy of it printed on bond paper. You don't get the original. The original sitting in the DTCC, or Seed and Company, basically, is the predecessor to the DTCC. And then when you die, your death certificate is what? Again, a copy of something printed onto a piece of bond paper. Why? Because they have to bond everything that they're doing. Why? Because in case the actual heir shows up to claim it. And that's what they're deathly frightened of. They're trying to rush everything. Biden, in all his illegality, is trying to rush everything through as fast as they possibly can to wipe away any remembrance, any understanding of what we teach here. Because we're coming for them. We're coming for the entire gross estate. We're coming to take everything back. And what they're going to do is they're going to do everything from civil wars to fake pandemics to crashing stock markets to everything you can possibly fathom to stop what we're doing here. Because we're the only ones that are doing what is necessary to end the system, the totality of the system. Because this is where it starts. It starts with the administration of the estate. Now, if you think there's no current Roman civil laws, statutes, acts, ordinances, and codes that still use this language, you would be wrong. Notice, and this is also something I got covered last time, so I'm not going to go over this again, but it's in the Illinois statutes under the Conveyances Act, and it gets into livery of season and what that is, and being a full age, and so on and so forth. So again, I'm not gonna cover this again, so I'll just scroll down to the Cestui by Act part. So, but again, notice the importance of being the heir in all this, not the damn beneficiary. They're two different terms in law. People that keep wandering around and saying, "Oh, just claim to be the beneficiary, and you can, you'll be fine." Nope. Because one of the benefits would be, again, to go to jail. If you claim a benefit instead of claiming the whole entire gross estate, there's a Latin term for that. It's a term in law. It's called beneficium abstinente. And what it means is that if you choose to take a benefit, you abstain from being the heir to everything else that's there. So every single time that and a beneficiary is an aspect of a trust, because you always there's 3 different sides to a trust, okay? There's the executor on top, the trustee, who does what the executor tells him to do, and then the beneficiary, the one who takes the benefit from whatever's in the res, in the center of the trust. And if you choose to be any one of these 3, any of the bottom 2 for the exception of the executor, you're going to be told what to do. And you're going to take what's given to you, and there isn't going to be anything you can do about it. So what you got to realize is that they've been doing this for a very, very long time. So this goes back to the Cestui Act of 1666. Cestui basically means by what right do you live? So under the common law, you're being given your entire gross estate when you come of full age and have been found to be living. So notice the importance of having been found to be living here in the Cestui Act in 1666. This is just 1 year after the filthy Ashkenazim burned it all down in London, right? After Oliver Cromwell let them back in. They burned London to the ground, and then they brought this filth into existence. So this is section 4 of the Cestui Act. If the supposed dead man, because they killed 70,000 people, false flag, killed 70,000 people, and then they bring this in so that they can basically control everything. So the proposed dead man proved to be alive, then the title is revested. So he has to prove. So the presumption is that you're dead. You have to prove to be alive. Action for means profits. This is middle lord, or that means middle lord, which has to deal with an aspect of feudalism, which I won't get into. So, but anyway, this is the important part down here. So, provided always that any person shall be evicted out of any lands, tenements by virtue of this act, and afterwards, if such person or persons upon whose life or lives such estate or estates depend, shall return again from where? Beyond the seas. You're considered to be lost in the sea of commerce. Okay? Or shall on proof, that's not a misprint, that's just how they used to spell it, or shall on proof in any action. So what do you got to prove it in? In an action. To be brought for recovery of the same, that's recovery of your state of the same, to be made appear to be living. So you have to do what? You have to prove and appear to be living. But where do you have to do that? In an action. So what do? What's the action? Well, it's a proof of life and proof of age inquest. That's what we found out we have to do. That was the remedy back then. Is there any remedy that mirrors that remedy here in American jurisprudence? No. That's why we had to create it. But remember this? The people of the state do not yield their sovereignty to the agencies that serve them. So guess what? If we're sovereign, we can create the remedy. What does the king do? He opens his court and he creates his remedy, right? Yeah. So that's what we did. We said, okay, if there's no solution, there's no remedy that the attorney's going to give us, because of course, why would they? We had to create our own. So that then forced the tenant who was ousted from the same as his or their what? Executors, administrators, or assigns, shall or may re-enter, repossess, again, that's not a typo, that's just the way you spell it, have, hold, and enjoy the said lands and tenements in his or their former what? Estate. For and during the life and lives or so long term as the said person or persons upon whose life or lives the said estate or estates depend. So, does your life depend on your own estate? Yes, it does. That's why you can do all of the Vocational Science of Freedom status docs, and no one can say anything about it, because it specifically says in the Magna Carta that matters of life and limb cannot be denied and shall be considered gratis. So, when you make it a matter of life and limb, say, yes, my life depends on my own estate, it must be considered gratis when you do a proof of life and proof of age inquest. So, to continue, so on life or lives whose estate or estate shall depend, shall be living, and also shall, upon action or actions, that's the proof of life and proof of age inquest, to be brought by him, right, the heir, or them, meaning all the rest of us, against the leaseors, revisioners, or tenants in possession, there should be a space there, tenants in possession, or other persons respectively, which since the time of the said eviction receive the profits of the said lands or tenements. What would the profits be? What would the profits of the said lands or tenements of our own estate be? Would that be property taxes? Sure. And any other fine or fee that they've come upon us and made and charged us with for the use of our own estate. All of that would get wiped away, and they'd have to bring it back and give it back to us. All of it. They have to do a full accounting. Okay. And again, recover, and this is even aside from having to give all that back, recover for damages the full profits of the said lands or tenements, respectively, with what? Lawful interest. Do you have any idea? There isn't enough money in the world. Literally, that's not a joke. There is not enough money in the world if every single American claimed their estate and then filed suit in this way against them for lawful interest. There is not enough money in the world. That's why the whole entire system is bankrupt, and has been for quite a while, but just to make a point here, there would never be enough money in the world to pay all that back for what they've done, which is why they're deathly afraid of what we're doing. So, and for the time that he or they were outed of the said lands or tenements and kept or held out of the same by the said revisioners, leaseors, revisioners, tenants, or other persons, who after the said eviction, now the said eviction is basically the second that they presume you to be dead, right? Remember the start of this, the supposed dead man proved to be right. Well, the eviction happened the second that the presumption kicked in that you were dead. And what we said, what was covered in last class, is all of the presumption of death, which I won't go back over. But that's when the eviction happens, okay? So, receive the same profits or the said lands, tenements, or any of them, respectively, as well in the case when the said person or persons upon whose life or lives such estate or estates did depend, or are or shall be, dead at the time of bringing the said action or actions, if the said persons were then living. So again, this is a capacity that you still have open to you. So they presumed you're dead. Don't care. Bring an action or actions to prove what? Prove to be alive. And remember the proper term. Do not use the word alive. Say having been made appear to be living, or say I've been found to be living. That's the best way to do it, so that you're in correct terminology in regards to this and what they did back then. So that's the filthy Cestui Act for you. So in short, that said, come back and prove you've been found to be living, and or prove you were living at the time of your eviction from your estate, and you'll get your estate back with interest. Now, if you think that some act in 1666 has no force or effect in the United States, again, you'd be dead wrong. Pun intended. Now look at this and see what the courts are trying to destroy: the rights of the heirs, estates. Now this is just a court case, but it gets to the point of what they're doing here. So we find that, quote, where there is a capacity to take and hold, the only thing wanting is the franchise of succession. Remember, only corporations can have successors. Living men and women have heirs. So, where there's a capacity to take and hold, the only thing wanting is the franchise of succession, so that the property of the society may pass to successors instead of heirs. Interesting. This and other franchises are the legitimates which unite a body of men into one and knit them together as a natural person, creating a corporation, an invisible and corporeal being, a metaphysical person, existing only in contemplation of law, but having the properties of individuality. What did they want? They wanted everybody to become and be sucked under the crown. What happened here? We fought a war and we kicked their ass, and then what did they do? By force of arms, we destroyed them. What did they do? By force of insight, they conquered us again. Because no one is waking up. No one is learning the law. You want to consider yourself dead to the law and not think it's important to learn all this? You will be administered for your whole entire life. You will be a slave under Roman civil law. And you'll deserve it. Because the ignorant, as far as I'm concerned, are as good. They deserve being slaves. If you do not wake up and learn what is going on and then pass it on to every single other human being that you know in America, you deserve to be a slave. And when the time comes and they say, well, little Mr. Person, you're supposed to do this, and little Mr. Person, you're supposed to do that, what are you going to say? Are you going to say, no, I'm not an infant? Or are you going to already have your doc set done and then already have it served on them, so if they try to do something, you can say, hey, moron, I told you years ago that I wasn't part of this game. but now that you've attempted to administer my estate, now I'll take you into binding arbitration, I'll bankrupt you. That's a contract that they enter willingly. And that's the contract that we create here. So that these kinds of presumptions, these kinds of court cases that the filthy attorney and the Crown and the United States Federal Corporation would love to have you wander into like a moron, stop happening. Now, is there a remedy in the common law, and does the common law exist in this nation? Question mark. It sure does. But this one is in Illinois statutes proving this. There are statutes in every state that show this fact regarding common law. And I've found this in many other states other than Illinois. And this is almost verbatim exactly what the statute is in every single state. You will find this same statute. So, this is Illinois statutes. This is the site. Section 1. That the common law of England, so far as the same, is applicable and of a general nature, and all statutes or acts of the British Parliament made in aid of, right, which would be what? Well, we just fucking read, the Cestui Act. And to supply the defects of the common law, not because the common law has defects, but because Roman civil law has things called trusts and usufruct, which the common law doesn't recognize because it's Roman filth, right? But anyway, that's the statutes, to supply the defects of the common law prior to the 4th year of James I, accepting the 2nd section of 6th chapter Elizabeth and the 8th chapter of 13th Elizabeth, and so on and so forth. These are when they're talking about chapters, as far as laws are created, they always do it by the reign of whatever king or queen was in reign at the time, on the throne at the time. And which are of a general nature and not local to that kingdom, shall be the rule of decision, and shall be considered as of full force until repealed by legislative authority. I haven't seen any state specifically repeal things like, the Cestui Act, or any of these other matters that we can also use against them. See, this is a double-edged sword. We can use this as an aspect of making sure that our remedy is properly done at law. Because if they ever question it, we can come back and say, look, it's in your statutes. This is something you have to follow. This is Roman civil law saying that the common law of England is in full force and effect. So you can't deny me a common law remedy to claim, have, and hold my entire gross estate and put you under contract in case you, some filthy administrator or any other idiot attorney, attempts to administer it, which includes keeping an account of it, bonding it, chopping it up into pieces and putting it into different... I don't care what the administration is. If I can prove to a lawful common law arbitral tribunal that you've administered the estate, you are stuck to the contract of which you've willfully entered into. So, another interesting stuff. Now, if you don't think that the Cestui Act from England has anything to do with anything, well, guess what? They have the verbiage right out of that in the DC Code. Failure to proceed as ordered. Subsequent proceedings, commissioners, presumption of death. Right? Ooh, what's that? Presumption of death. Right of possession. If a person upon whom an order, as prescribed by this section, 16-1152, is served, refuses or neglects to produce the person upon what? Whose life the prior estate depends. That's out of the DC Code, my fellow sovereigns. So, this is directly out of the Cestui Act, upon whose life the prior estate depends. So, do you think that your life depends on your estate? Yes, it does. And they're showing you clearly in the DC Code that yes, it does. Or else they wouldn't put this verbiage in here. In the manner provided by the order, the court shall order him to produce the person in court or before commissioners appointed by the court at such time and place as the court directs. 2 of the commissioners shall be nominated by the petitioner, and they shall serve at his expense. A certified copy of the order shall be served upon the person required to produce the tenant for life in the manner provided by applicable rules of court. By the way, your aspect of a tenant for life, you're the tenant of life of your own estate. That's the point, until you're actually dead. The commissioners appointed shall make and file with the court a return showing the results of their investigation and their conclusions. Well, there's only one conclusion that can possibly happen. Hi, I'm the sole lawful heir and executor of the estate. Yeah, I've claimed it. Now give it back, because my life depends on my estate. my notes here. So the red is a direct quote from the Cestui Act, which I just mentioned, and it is referring to the production of the infant person before the court so that he may have his livery as stated in said act of England. And only thing to find out who is the petitioner, because it should be the heir, it should be you. And if it's anyone else, it's fraud, because the guardian should know if the ward be alive or dead already, which they never do. And technically, there's another part of the Cestui Act, which I did not read, but I'll make note of it here, is that they're supposed to send out 3 search parties. 3. They're supposed to send out 3 search parties to find out if you're living or dead. Now, there's been discussion about, could the first technical search party, now I don't really go along with this, but I suppose you could make an argument for it, that the first search party is the announcement in the local paper of the child's birth from the hospital. Maybe. Again, I wouldn't go along with that, but there's been talk about that one way or the other. Could the other one possibly be, I don't know, something that might happen when you're 18 or 21, maybe? I don't know. There's different possible things that people have argued that it might be. Well, none of them hold up to what the Cestui Act says they're supposed to do, because they know you're not dead. They know you're not dead. It's all just based by presumption. So, of this section, is served if the person is served refuses and neglects to produce in court or before the commissioners, as the case may be, the person upon whose life the prior estate depends. Again, there you go. It shall be presumed that the latter person is dead. What? It shall be what? Presumed. All of this filthy shit is all based on presumption. It's right in your face all the time. And the court shall issue an order permitting the petitioner to take possession of the property, as if the person were actually dead. Really? Who do you think that is? The Bar Association. Right? So what does all this lead up to? This is how I see this unfolding into the common law. Now, pay no attention to this because we got wiped off of Discord, so that's don't worry about that contact there. So just contact and get on the Gilded server, and anybody can. All you have to do is click on my name. Yeah, it's left click on someone's name, and then you just go to message, and anybody can message me here on the Gilded server anytime you want regarding any of these questions, or prove me wrong. I'm always up to being proven wrong. If you guys can prove me wrong, I'll alter every single bit of paperwork, right? Because I've put this out for years. If anybody can prove me wrong, I'll alter what I'm doing, because I'm only going to walk in truth. I'm only going to do what is correct. This has nothing to do with it is the way it is because I say it is. It's because I can prove it. So if anybody can prove me wrong, please do so. But if you want to contact me on the VSOF Gilded server. And if you want to take out these idiots, you can send the trade rounds. $21 actual is the amount. The P.O. box for the information for the status docs can be found under the information for the VSOF, which I just went the wrong direction. It can be here under membership and prices. And if you scroll up to the top, you can click on the mega link, and the mega link will take you to the folder that will show you all of the various different things that we can do here at the Vocational Science of Freedom. Not the least bit is the settlement of the estate, which is what we were just talking about. So you get your status docs done. You record them onto the public record. You file your 32 EIN estate number for the IRS. This is an SS4 form. That's what the form is called. It's an SS4 form. And what that does is the IRS will send you back a 32 EIN estate number. It's not a Social Security number, because when you get the EIN number, it says right on the little letter that you get from the IRS, it says so-and-so executor of the such and such estate. And then it'll give you an EIN number. Once you're the executor of the estate, you can use this EIN number to then open bank accounts, of which will no longer be able to be taxed. Why? Because every single W-9 and 1040 form of the IRS is Class 5. Class 5 is gift and estate tax. It is not income tax. Why are you paying a gift and estate tax for the use of your own property? It's because you haven't filled out a 32 EIN form and told this glorified accounting firm called the IRS, whose only job is just to take an account for all of the abandoned infants' estates. I mean, that's all they're doing. I mean, these guys, if you tell them what to do properly, they'll do what they need to do because you're just not doing it. So then you can set up a bank account in the name of the state with the EIN number. You're the executor or executrix, as the case may be. Then you can open a affordable probate case and file all of the public record numbers that you've already filed for the VSOF status documents. And then you could file a probate case and say, hey, now I am demanding that everything else come forward. And then you can get letters executor from the probate court as well, right? And then you can go around to the DTCC, Fidelity, and all the other banks and governmental organizations that are holding your minor accounts and everything else. Everything that everybody's been trying to do, the stuff that Heather Ducey and all these other people were trying to do for years, they never did the preliminary proper work, which is settlement of the estate, to claim the estate. You can't go using something which you don't own. If they're seeing you as an infant and as a trustee, well, then you don't have the right to title. An infant has no right to title. That's the very most important part of that presumption. Infants have no right to title, and certainly dead men have no right to title. But if you get rid of those two, okay, now you have right to title. Okay, now once you do that and you rebut the presumptions, then and only then can you be part of the people of the state, lowercase s state, that do not yield their sovereignty. Sovereignty is an aspect of title. An infant can't hold that. So until you get rid of that presumption, you can't have this. You can't have this protection. In fact, you can't have any of the protection of any of the constitutions. Any of them until you do this. You will be seen as an infant. So then you collect everything, put it into the account, pay all the lawful taxes that there might be, which really there wouldn't be from the standpoint of common law, because it's yours. It's not passing on to somebody else. It's yours. So you're just doing the accounting, collecting it, and putting it all into one thing, and then you take it and distribute it to yourself. Case closed. And nice day. Have a nice day with hundreds of millions of dollars at your disposal, because that's what is sitting at Fidelity. We have the capacity, and there's not the VSOF personally, but there's a group that has access to the Fidelity bond accounts, meaning the Bloomberg terminal, which is basically a little thing that looks like a little laptop. And they will do an audit for you, and they will take your birth certificate, and they will run the QSIP number and find the Fidelity account, the Fidelity bond that's connected to your BC. Well, guess what? That's yours. That's your bond. So if Fidelity doesn't want to give it up, then you could put them under contract with the rest of the status docs, because clearly they're doing what? They're administering your estate. So if they don't want to give it up, take them to binding arbitration and be done with it. So again, if you guys want to contact me, you can do so on Gilded, not Discord. Again, I need to get rid of that. And with that, we're reaching about an hour. So unless anyone has any questions, I will conclude for tonight. And I thank everybody for showing up. And afterwards, we can talk amongst ourselves.